And we'll take a quick break. And when we return, we're going to be asking questions because the former Attorney General is asking very serious questions about the claims put out by Dominic Ayine, particularly about a certain memo that Dominic Ayine alleges that Dame ignored and proceeded to continue the prosecution of the now governor of the Bank of Ghana. I began the show by reading to you. Let me read that to you again before we go on a break. A study of the facts of the case indicates, I'm not quoting from Dominic Ayine's presser or the press statement he issued. I'm quoting from the memo that Godfrey Dame says does not exist. That memo says, a study of the facts of the case indicates that the initial facility of 300 million Ghana cedis has been recovered, leaving 150 million outstanding. The office has confirmed from the Bank of Ghana through Mr. Alexander Tarr, PW2, that's prosecution witness 2, that the interest from the outstanding amount is presently being serviced by UMB Bank. Mr. Tarr also indicated that UMB has an amount of 150 million locked up with CBG. It is expected that when the said sum is released to UMB, the loan amount for which A3, that is accused person, the third accused person being Johnson Esiama, for which A3 was charged with causing financial loss, will be repaid to the Bank of Ghana. This therefore may render the charges proffered against A3 moot, leading to his discharge. We'll be right back. You're welcome back. This is Newsfile. It's your most authoritative news analysis platform, and here on Newsfile, we put Ghana first. Some of your messages. And this one says that Collins Little Tete, the disorganized nature of the raid and the conflicting narratives from the OSP and national security have eroded public confidence in the institutions tasked with fighting corruption. This could hinder the effectiveness of future investigations. Musa Abator says it's clear that Ken Ofori-Atta is avoiding accountability. If someone refuses to submit to due process, it is only right to declare him a fugitive and wanted. No one is above the law and due process. Okay. No one is above the law and accountability must be upheld for the sake of justice and transparency. KD says the OSP's excessive grandstanding during press conferences undermines the seriousness of the situation. His emotional posture erodes public trust and calls for a more professional approach to restore confidence in his office. Christopher says if NPP folks feel they should be treated differently from other Ghanaians, they treated NDC folks in this matter, and it was okay for them to do so. Suddenly, they know that someone is not following the laws that they conveniently ignored just recently. Prince Henry Nkofori-Adua says if the former president, John Mahama, was investigated by the OSP and the NPP saw nothing wrong with it, why should Ken Ofori-Atta not be investigated? If Ken Ofori-Atta is above the laws of Ghana, is he above the laws of Ghana? Let us support the NDC government to give us the Ghana we all want. Nobody has said he should not be investigated. Abdullah Pagla Issa says it is right that no one is above the law, including Ken Ofori-Atta, but the footage that showed the invasion of the Jakpa-led security team like thugs whisking his children out was the lowest ebb of democracy and must be condemned. Mauli Atashi says, I like the way Frank Davis speaks with soberness when they are at the receiving end of one so-called mistreatment by the system. Flip same, and you will hear him speak with venom. in the name of accountability and allowing the system to work. And we are learning from the mistakes. You need to observe Frank Davis a lot more carefully, and you may see that there may be some difference. Tanko Osman says Frank Davis and their likes claim the events at Ofori-Attah's home were traumatic. Have they forgotten how Ken's economic decisions have claimed life, DDEP, etc.? Ken doesn't deserve any sympathy. Kwesi Sapong says, someone sanctioned that raid? How did JAPA know that the OSP was intensifying its actions against Ken Ofori-Attah? Big question. Who sanctioned the raid? We must demand the truth, and those responsible for this unauthorized raid must be held accountable. And the many of you who are making the target, JAPA, there are others who are telling you that JAPA is the same person who led the operations that led to busting, a situation in millions of, counterfeit money, dollars, and so on around the place. So allow him to do his job. And then there's someone also suggesting that OSP has an axe to grind with Ken Ofori-Attah, particularly Gabi. Okay, interesting comments there. But when I hear that, I say that may be good, because the understanding we have is that the SP was recommended by Gabi for appointment. So if today they don't see eye to eye, perhaps it is for our good. Perhaps it is for our good. All right. So now let's get to, let's get to oral before the nolli prosequis, and they are together. So let's take them together. So oral, Operation Recover All Loot. It's saying that potentially they can recover 21.19 billion United States dollars. That's like, if we got that money, we won't go to the IMF for like how many years? Mm-hmm. Like 2 decades, we will not go back to the IMF. And what a country this will be. Well, those who are crunching the figures and looking at the data say, relax, take it easy. You may just recover some 12.5% of what you are looking at. On that note, let's begin with Bright Simmons.
So do you want me to start with the famous nolli prosequi issues, or the...
if that's how you want us to start, I wanted you to look at oral into that.
Okay, yes. So you want me to, but you want to comment on...
That's right.
At the same
That's
time.
right. Mm-hmm.
I think with oral, first and foremost, we have to be very clear that a lot of people in this country are excited about oral. And I think those political actors who've made it a habit to try and caricature it and make fun of it are not attuned to public sentiment. And I think on the MPP side in particular, there is tendency to be out of touch with public sentiment, and you have to watch it. Going into the campaign, I had occasion to listen to some of their most senior people talk about the fact that, Ghana is not Accra, and all this inflation talk is nonsense. Mm-hmm. And I'm like, do you know the actual regions that were suffering most from inflation? So Savannah was the number one. So sometimes it's not data informed, it's not data driven, and there's this out of touch attitude about some of these matters that I think doesn't serve the MPP well. But there are others as well. So my view is, first of all, oral is extremely popular. I know people who have said that they didn't buy into the entire NDC agenda, all this 24-hour economy and the rest of it. But if only the MPP will hold people accountable in Ghana and stem the flow of impunity, they'll be happy. Mm. So that's number one. Number two is we should treat oral as a matter of policy. We should think of it as a government policy. If it's a government policy, then measuring it effectively becomes critical. Because one of the big problems we have in policy making in this country is that we can't measure. So everybody throws their arms about, they do some PR, people get excited a little bit, then we forget about what exactly that they promised, and then we come back 4-year cycle, same thing all over again. Wash, rinse, repeat. If it's a policy, then the starting point is what problem are we trying to solve? And are the instruments we've designed a good match for the problem we are trying to solve? And how do we know we are solving the problem? Which is why I thought it was important to try and set some targets. So when I said that, if they can prosecute 50% of the cases, if they can secure 50% convictions, if of those 50% are willing to plea bargain and through that effort, recoveries can be made, then to my mind, they've done well. I was not saying that I'm forecasting that they will be able to retrieve 12.5%. I was setting a stretch target. I was saying that the target for me, which will be a reasonable target, is that if there's $20.8 billion or $28.9 billion, I've also seen $21.1 billion in other documents, that they've set as the damage that have been caused to the country.
Officially, what they reported to the president was 21.19.
Good. But the confusion that I think has arisen is that some people think what they are saying is that you can recover all 21.1 or 20.8. What they were saying is that this is the damage that they estimate from these cases that they've examined. So the damage to the country, the fiscal damage to the country is not necessarily the recoverable target. So I'm trying to set up a recoverable target, knowing that that is a stretch target. Why do I say it's a stretch target? Because when you look at the list of cases themselves, you will discover that in most instances, the likelihood of recoverability is very low. So take the famous $4.5 billion from the National Service Secretariat
Authority.
That $4.5 billion is an estimate of harm. I don't have the methodology. What I do know, though, is that if you take all the budgets of the National Service Secretariat since it was founded to date, and you added all that, it will be $4.5 billion. It will be significantly less. If you take the 88,000 ghost names, it could be more. We don't know, right? Investigations have not been done. But the 88,000 that Forfeit State has identified, and I trust Forfeit State, and you multiply the income that these people, were earning, these ghosts were earning, and you come to, the region of about 1 billion cedis a year, and you say this has been going for maybe 3 years or whatever, 3 billion, you still don't come anywhere close to $4.5 billion, maybe 5% of that amount. If you take the COVID cases, or rather the COVID spending, where I think they are also estimating about $4 billion there, $1.5 billion, sorry, $1.5 billion thereabout. Most of that money, you saw it on the streets with all the free water, free electricity, food being thrown about, expenditure that was made or for Ghana Cares, which led to loans distributed randomly to all manner of people. Much of that money, we don't know if it's been covered. Ghana Enterprise Agency said they recovered some numbers. I'm trying to get the data. Nobody's giving it to me. But those monies have gone to a wide range of Ghanaians. My sense is that a lot of it was wasted. The fact that it was wasted does not otherwise mean, though, that you can use the criminal process to recover. And I think you, a lawyer, will understand this better than anybody else. To be able to recover through the criminal process, you must establish crime. Or at the very least, you must convince people that, as I gave this money as free water and electricity, I'm now so guilty. I'm going to put my hand in my own pocket and bring that money out. Think of the matter in relation to
National Cathedral.
National Cathedral is a bit more clear-cut in the sense that, the identifiable contractors, whether or not to be able to get the money out of them is another matter. But at least you could make the case that the money was ill-spent. I mean, we had the parliamentary process, which to me was inconclusive, about whether or not the contingency votes could be spent the way that they said it has been spent. Because my understanding, from a public financial management point of view, is that if you wanted to spend it in that way, the President, the Chief Justice, and the Speaker of Parliament should have agreed. We've not come to any conclusion whether or not. When you saw what happened in Parliament, it was a spectacle. Nothing much came out of that. We also know that, they've identified the Bank of Ghana quantitative easing as a problem. And they suggested that about $5 billion of the $80 billion cedis in spending was, in their minds, problematic. Yes, many of us have agreed that it's problematic. A lot of the inflationary cycle spirals that you saw came from that money printing episode. But whether or not, after that, having moved that money to banks, the banks having distributed that money through the country, people have spent it all over the place, you can actually use the criminal process to go to court and extract $5 million back. It's anybody's guess. So when I say it's a stretch target, it's because when you take these cases one after the other and you examine them, you recognize that recoverability will not be so easy. So 12.5% is not the forecast amount. 12.5% is the stretch target of how much of it they can get.
People who have, acquired lands that they say must cost between 700, as it were, $1 million instead of 500,000 Ghana cedis.
Good.
They would go to court and say, well, I acquired it through a due process.
Even if
so you're not going to get that money from them.
Even if you get it back, it's still real estate. It's not cash in the pocket of the government.
Okay.
You restore back to the government's real estate bank, properties that have been alienated from the state. But that is not cash. That's not money you can just simply spend. Okay. So when you do all the analysis and you go through each of those cases one after the other, you conclude that setting a 12.5 target, 12.5% recoverability target is actually a stretch target.
Okay.
Then you go to the next level of the analysis and you say, okay, most of us agree that this $21 billion you've identified is money probably not well spent. That raises a concern about waste massively, because $20 billion, as you rightly pointed out, is today nearly 30% of our GDP. And it's what? 7 times or 6 times at the very least the amount of money that we are, the IMF, begging to be disbursed to us. We've had instances where we've had to do domestic debt restructuring, etc. Because the IMF said, if you don't do that, I'm not going to give you a $3 billion loan over 3 years. $3 billion over 3 years. And then we have instances like this SML thing where they are budgeting about $3 billion. We know about $150 million have been, $140 million thereabout have been paid. Why do we have a country that goes and does an IMF deal? And there are programs that could potentially cost this country $3 billion over a 20-year time frame. So we cannot talk about ORAL unless we are committed as a country to fix policies that are wasteful. And fixing policies that are wasteful is not done through the criminal process. Okay. It's done through public policy where all citizens start to become vigilant about the design of these programs, and where sometimes there are inherent structures within the programs that make them very difficult to deliver value for the people. Last critical point on the ORAL issue. We go back to this point that it has to be a policy. So we talk about the target, the measurability, etc. Transparency is going to be very critical. I have argued that in a lot of these instances, the problems are embedded in the actual policies that are being run in this country. If they are embedded in the very policies that are being run in this country and the NDC is not willing to start reforming those programs, then we know they are not going to get money back. We've been documenting instance after instance after instance of policies that are wasting money. They've now been in office about a month. We need to see direction. SML, what exactly is the direction? Issues to do with Kelly GVG, what is the direction? Ghana card, people are not aware. Hundreds of millions of dollars is being spent on just national identity, where we have so many other priorities. All of these matters, we need clarity from the respective ministries and from the presidency, whether or not there is indeed a commitment. Then you have to think through the actual mechanics of delivering this outcome, this ORAL outcome. Prosecution is going to be important, investigation is going to be important. 2,417 cases. Most people don't realize the scale of that. I'll give you an example. In 2021, the total number of prosecutions by the Attorney General was 894. The total number of investigations by OCAL was 143, of which they could only prosecute 19. The target for 2022 was 50 prosecutions out of 400 investigations. NACOC, which may come in again in a future discussion, they could not prosecute anybody in this country for about 3 years. So prosecutions are not an easy thing to mount. So if you have 2417 cases, you need to really execute a number of critical strategies. One, recognize that some of the law enforcement agencies are in different ministries. UCO reports to Attorney General, the police and the CID reports to the Minister of Interior, the NIB, formerly BNI, reports to the Minister of National Security. All of these are investigation bodies thrown about. The Attorney General Department has to have a mechanism for executing ORAL that gives it an interagency coordination mechanism, the ability to draw upon the investigative resource of the different agencies. Secondly, they have to tell us how they're going to do these prosecutions, because their current capacity does not allow them to do 2,517 prosecutions in 4 years. Additional. Not when you are doing criminal prosecution in total less than 900. And lastly, if ORAL fails, now it's very apparent to us that it will be the failure of the Attorney General's Department, because they've been saddled with the burden. So I think transparency, communication, stakeholder engagement, clarity about the strategy will be very essential, because we'll be blaming them. if this target that I've set, it's a target for them.
Yeah. So let me do this quickly, and let's be brief about this so we can come to the nolli prosequis and the withdrawals and the contradictions that we are beginning to see, and the complaint is coming up a lot about, because you say you are recovering all loots, and yet you are sort of, as it were, clearing all the looters. This is a tough job for your outfit. And as we understand from Dominic Ayine, this is your brief. And he suggests to you 3 years, is it NACOP, had not prosecuted one case. We are complaining about OSP and how much they are not doing. Attorney General has been doing certain cases for 8 years, no results, and they have been terminated.
Yeah, thank you very much, Samson. Even though we call it ORA, which means recover loots, the policy framework for that goes beyond recovery of the loot. Definitely the loot will be recovered, but the ORA is designed to actually stop the loot in some respects. So we have stopping the loot, we have recovering the loot, and also to create some level of vigilance among the citizens. So that is another aspect of the ORA, and that has significantly been achieved, because now within a few weeks, the number of citizens who have reported what they suspect to be loot or crimes is just amazing. So that is also part of the ORA project. Now there is facilitation of what we call, investigation and prosecution. It's also part of the ORA. Now, as we speak, the Attorney General is in the process of establishing what exactly Bright said, an interagency committee for investigating these cases that have come. Because the Attorney General has realized that if the institutions of security and intelligence agencies continue to work in isolation, in silos, there's no way we can do much. So that committee is going to be the fulcrum around which all the agencies are going to work. Now, and also there is an aspect of the ORA which includes sensitizing the public. And it goes beyond the rhetoric of see something, say something. It is going to be a general education for the public that some things cannot be done. So, for example, the president has indicated that there is no way he's going to supervise his appointees acquiring properties that belong to the state. If you want to acquire property that belongs to the state, you probably have to resign and go and acquire it as a private person. That is enough education to the public that whenever you see that any person who is an appointee or is an exposed person who is acquiring certain state properties, you should know that it is wrong, it is against this government's policy, and you have to report it to whoever or the nearest police station or wherever. And then the ultimate thing is that the ORA is supposed to also punish. It's supposed to punish, because there is no way, recovery is not the end of this. People must be made to pay in terms of criminal sanction the harm they have caused this country. And that is going to be pursued. Now, the next question is, how are we going to do this, considering the challenges that we have in the
ORA, after submitting their report to the president, have they been disbanded?
So they have not been disbanded in that sense of the word. So the ORA program has, like I mentioned, has several aspects. So
what was a committee?
Yeah, what we saw was an interim committee to collate these complaints. And the committee served a good purpose, because, most of the times people see these things, and even when they are bold enough to file a complaint, they file it in a manner that no one can work with. Because sometimes the complaint system with the police and the regular, they are not accommodating.
So ORA is a project and not that committee?
No, it's not the committee. The committee is just the stage one, the preliminary stage of the ORA. The ORA is a long-term government, NDC government project, which contains the things that I've mentioned. So now the mechanisms of ensuring this, we have really appreciated the challenges with the criminal justice system. And in a few weeks to come, the Attorney General is going to outline some of the reforms that are going to happen. That certainly includes the tribunal system. The tribunal system is going to be restored in accordance with the Constitution, so that we would be able to achieve these goals. And there's no doubt that the nation, Ghanaians, are interested in this, because Ghanaians have seen over the years that the biggest problem we have is this loot system. So the one of the mechanisms which the Attorney General will be outlining in a few days to come will be the tribunal system. There will be a bill which will be placed before Cabinet to restore the tribunal system. And we believe that that will augment the system.
That can be another argument, because that seems to suggest as if the courts are clogged and there's no space. That's why you want the tribunal system to add on and to take on this.
For all you know, it is because of the non-use of the tribunal system which has made the court even clogged. Because, you see, the Constitution was designed with institutions in place. Some way, somehow, political discretion has refused to use some of the institutions, thereby creating a disbalance. So we believe that if we activate that which has been lying dormant for years, it may augment the system. That is not to say that the system is something that cannot work, but it is part of the general justice.
You were supposed to give us a brief on this, because we need to go to the next issue. And let me go to Frank Davis, because as we understand, the NPP has raised issues about the conduct of oral. You say looters, and you are making publications even before you have concluded investigations. At the level of just taking information, you are doing things that predispose people to defamation. Now, listening to what is going on, Frank Davis, you have hope that oral is now getting into a properly, so to speak, legal framework to attempt to recover, make recoveries.
Thank you again, Samson, and good morning to my friend, whom you just told has the burden. Justice. Justice Ramsay, Deputy Attorney General Minister for Justice Designate. Is it?
Yes, he's listening to you.
Well, Justice, would you respond? Anyway, something.
I didn't hear what you said.
I
good morning
know,
to you.
Oh, good morning, Senior.
Yes, Justice. I don't know, but I think I have taken very useful insights and very cogent education from Bright Simmons, and I'm glad for that. You see, we should put all this thing, this oral, whatever, into perspective. You see, not drum home huge expectations only to run into sand. I mean, for me, I don't have anything against oral. Initially, my complaint had to do with the constitutional backing and executive authority for oral. But that is gone. I mean, we don't have a sworn-in president and all that. So fine. But something, you see, there's a huge gap between gathering information and evidence. I mean, as trained lawyers, there's a huge gap between gathering information and evidence. The two stand apart, they don't stand together. You see, so when figures are being bandied about, I mean, look at the statistics and the education Bright Simmons has offered about the prosecutions the Attorney General itself was able to conduct. IOCO, other investigative and prosecutorial agencies, what they have been able to do, even with their investigative mandate. And it falls short of general expectations. But that is a stark reality. So when oral says we have taken 2,000 complaints and there's so much fanfare, noise, and what are complaints? Look, 1 million trillion complaints do not gravitate into evidence. You have to sift out.
A multitude of suspicions cannot constitute evidence.
Can never. You see, so I think we should hasten slowly. And now I read on BBC, it is gone haywire that Ghana stands the prospects of going to get 21 point something billion, not billion, no. Some say $1 billion, 21 point something billion. But something. We have civil trial and we have criminal trials. Even when somebody owes you money in court, something you know, you are a leg boot advocate. you are not one of those lawyers who sit in their offices and proclaim they are eminent jurists and eminent lawyers. You are a leg-boot practitioner. You run in the court with all of us. Of late, some of us have given up for you to take over. But you know what you have to go through when even there's a simple order 14 proceedings and there's a challenge. You know what you have to go to prove that indeed somebody owes you money. So is it with criminal trials. The mere fact that you claim somebody has stolen money is not the end of it. The duty, cardinal, all time, is always on the prosecution to prove the guilt of the accused person beyond all reasonable doubts. The accused person has no leg to prove his innocence. You have to prove that I have stolen money or whatever criminal offense you charge me with. Now, if these complaints are handed to the AG's office, this so-called 21.19 billion unspotted recoverable money, Bryce Simmons, with his expertise in the field, says they can only recover 12.5% of that amount. Granted, let's take it that you'll be able to recover.
That's for him the stretch.
Yes, let's even take they can recover. How are they going to recover those monies? They will have to go to court. Now, with criminal prosecutions, with criminal trials, even if at the end of the day the accused person is found guilty and he doesn't have the money, he or she doesn't have the money, how are you going to recover? You see, a restitution order could be made, but the restitution order is contingent on whether or not the person has the funds.
Chasing a man
unless you can prove. How are you going to recover that money? And now we see. So you see, this twist, with these complaints, whether they are civil in nature, they are criminal in nature, we don't know. But now, I am gratified by the fact that now the AG has been sworn, has been given his appointment of authority. Very soon, Swemsai will also go and get his appointment confirmed. And then the real work starts. But I don't shed any tear at all for justice. You okay. You know the conversations. Let me address him. You know the conversations I've had with you, Justice. You see where the real work is. Baby, you want chop deputy attorney, now you chop him. Let's go see the work.
Yes, let me bring in.
So I am for myself. When money is going to be recovered for the state, it's the economy of Ghana. Something. It is not me, Frank Davis.
Thank you.
So we are all happy.
All right.
But let us be ginger. Let us tread cautiously about the amounts we throw about.
Mr. Yao Daniel Domelovo, thank you very much for joining us, and we'll make this very brief. It does look like this is such a tall order, and you have even had the cause to express some. I don't know how to call it. You said you'd be disappointed if this is not followed through, because you can see that it's potentially you may not get anything out of this, right?
Well, I good morning first to your listeners and viewers. I don't think so. I am very optimistic that something can be recovered or come out of the data or the information that we gathered. That is the reason why I said I'll be disappointed if we leave it at that point. I was listening to the submission of the previous week. I don't know. However, I agree, and I don't think any of us have that this is a judgment that we are going to take. It's a good just information we have now, and a complete is done. So if we have done this to a sub fund, then they go. You know what they for? We need a in the way to lose, and I think that when recovery is difficult. But that's where we can get. If we get to where the court counts that this money cannot be collected, or this money has been collected, then we have, even if we are not to collect, we should go to hold people at. Thank you.
You have said majority of the cases need auditing to confirm wrongdoing. And that makes people think, so what have we been up to?
The point I'm making is that we have not done any investigation. Based upon our audit, our mandate, we only collected claims that have come to us. Therefore, if we don't do an audit, and in some cases, investigation, I don't think we can establish a prima facie. But then, running into the situation where people say that it is recoverable, it is not recoverable, these are all opinions, and I think they are all entitled to their individual opinions.
Nonetheless, you are hopeful that this will take us somewhere, and it will take us closer to the 21 billion.
Exactly. In fact, to be honest with you, I saw like someone's figure, and I laughed, and I said, well, that can be the case, but just what we refer to as guessing, is guessing and estimate. Okay? It could be more, it could be less. And there are several other cases that have not even added to the 21 yet, which can increase balloon the frequency twice or 3 times. It is also possible that after investigation, it may drop drastically. Being an auditor or an accountant, I know that your initial findings may be very different from your final conclusion. At times, what you see at the initial point is just the tip of the iceberg. Your final conclusion is multiples of it. It is also possible that at the end of it, what you found at the beginning is so huge, but at the end, it is something very little. But it is good to go the full haul or the full section just to give the assurance that people will be held accountable for their stewardship or for the use of public funds.
Okay. Thank you very much, Daniel Domlevo, former Auditor General, and he has been a member of the oral committee that did the gathering of the information. We need to move on, but Justice Ramsay wants to say something in a minute, quickly.
Yeah, I think the attitude of looking or trying to kind of ridicule the oral and make it look like one of the usual things must be discouraged. And that is because, you see, this project is something that comes from the heart of the Ghanaian. And we should all do what we can to make... We are not pursuing some political, sloganeering project. As I've said, the information that have been gathered have been brought to the Attorney General's department. The Attorney General is sifting through all this to make sure that the real facts are brought out. Then we can give a definite figure. For now, it is just estimate, but when you look at the record, you will know how much you are likely to prosecute for, how much you are likely to recover. So I think that rather than sit behind and try to ridicule the process, as has just been done, we should be ready to, believe in the desire of the Ghanaian and pursue it, which is contrary
We take a break and return to OCAL, Operation Clear All Loot. Manasseh introduced that, and some people are really angry. How dare you say that? But very interesting, isn't it? But Justice, always remember that the Auditor General's report every year throws up $1 billion or more, but we end up not really recovering anything. Occupy Ghana did an auditing of about 5 years of the Auditor General's report, and it showed that money stolen and money misused, cumulative, was in excess of about 3 times what we have gone to the IMF for. We'll be right back.
The decision to withdraw the charges against Mr. Johnson Pundit Asiama for a simple reason that in the course of my review of the cases, my attention was drawn to an internal memo prepared by the Prosecution Division of our department for the attention of the former Attorney General, the Honorable Godfred Yebo Adame, which recommended that the charges against him be dropped. This is very significant. This is an internal memo prepared by professional prosecutors advising the Attorney General that the charges against our current Bank of Ghana, the Governor of the Bank of Ghana, be dropped. Note that Mr. Johnson Pundit Asiama was charged with contravention of the Banking Act for granting a facility of $300 million 300 million cedis to Universal Merchant Bank, and for causing financial loss to the state in the sum of 150 million Ghana cedis. The internal memo, which I just cited earlier, concluded as follows. This is very instructive. It says, a study of the facts of the case indicates that the initial facility of 300 million has been recovered, leaving 150 million outstanding. This office has confirmed from the Bank of Ghana, that is, the Attorney General's office has confirmed from the Bank of Ghana through Mr. Alexander Tarr, that is PW2, prosecution witness 2, that the interest from the outstanding amount is presently being serviced by UNB Bank. Mr. Tarr also indicated that UNB has an amount of 150 million locked up with CBG, that is Consolidated Bank, Ghana. It is expected that when the said sum is released to UNB, the loan amount for which A3, that is Johnson Pundit Asiama, was charged with causing financial loss to the state will be repaid to the Bank of Ghana. This therefore may render the charges proffered against A3, that is Johnson Asiama, moot, leading to his discharge.
I speak from experience as the nation would note that Dr. Ayine and other leading figures in the NDC and the government of the day were counsel in many of the cases he has discontinued. I say that indeed it is not uncommon for defense counsel as Dr. Ayine and other NDC personalities were, looking at the same set of facts to come to different conclusions, informed by their varying understandings of the law and, of course, the undeniable political considerations they hold. However, I dare say that in taking decisions as monumental as drawing those cases, the only consideration has to be the national interest and not that of defense counsel. The analysis I make of the reasons advanced by Dr. Ayine will expose the questionable intent behind the withdrawal of the criminal cases. Dr. Ayine's unfounded allegation insinuating unethical conduct on my part in the conduct of the ambulance trial, Republic vs. Kasera, Tuforsen, and two others is highly disingenuous and rather, unfortunately, recaps the series of falsehoods persistently published by foot soldiers of the NDC and other uninformed members of society. I must say that I find it quite ironical for Dr. Ayine, who is a subject of disciplinary proceedings for professional misconduct, still pending at the General Legal Council, filed by the Honorable former Chief Justice himself, to accuse me of unethical conduct. In the interest of the nation, the case of professional misconduct pending against Dr. Ayine at the General Legal Council should have been determined before the parliamentary assessment of his suitability or otherwise for the high office of the Attorney General and Minister for Justice of the Republic.
Right. So, Justice, what a contradiction. Perhaps before I hear from you, let's begin with Bright. What a contradiction. Ghanaians are asking, and that's a legitimate question, isn't it? Yeah. That you say, we want to recover all loot, and here you are, not allowing the court to prosecute, to try people, and you are clearing them.
So, I mean, yes, obviously everybody, took serious interest in these developments. I think the right way to approach it is to look at the decisions case by case, and at the same time to consider the general principles that you've pointed out. But I was surprised when I, saw the former Attorney General elevating the bar of governance to that height. Because you recall that when he was in office, we had occasion to call him the most partisan Attorney General that we've seen in our history, at least as far as my adult life. So I was very impressed that, he'd elevated the bar of governance so high. I remember in the J. case, in the Saul case, the famous lack of representation case, the Atuforcing case, I had a lot of occasion to disagree with the way that he was conducting himself as Attorney General, because I felt he was being extremely partisan. But nonetheless, his intervention was very informational. And I think for that reason, that was very good. The only, low point was when he sought to suggest that the current Attorney General, because he has a case at the General Legal Council, is somewhat unfit for office. I think that was very unfair because for listeners that are not aware, they would assume that this was a matter that goes to his personal integrity. It's not at all. This was a political matter. He had expressed concerns about how the Supreme Court had conducted itself in the matter of the election petition. And that was the only reason he was dragged to the General Legal Council. It had nothing to do with his personal integrity whatsoever. And I think we need to make that point very clear. But to go back carefully and look at these matters clearly, we will have to start with some of the cases. And because we don't have time, I've selected only 5 of them so we can begin to, add some flesh to the skeleton. I agree.
5 of them is almost all of them. No, 7 cases in all.
7 cases in all.
Yeah.
Yes. No, I thought it was 20 cases.
No.
That they were working towards. Okay, anyway.
What they have done so far.
What they have done so far, okay, fine.
7.
I heard 20 from somewhere else, but I'm mistaken that they were working on 20 cases and the 7 had been just announced. But for the 5 cases that I have, I think the decision to stop the prosecution of Democracy was just brilliant. And if they go ahead and do the same for the treason trial that everybody in Ghana, except themselves, are aware is a complete caricature of justice, that will also be brilliant. I also agree completely with that two-forcing case because I investigated that matter myself as an independent analyst and looked carefully at it. I think it's one of the worst abuse of the prosecutorial discretion we've seen in this country. A use of a letter of credit is itself a risk management instrument. The reason you use a letter of credit is because there could be problems with the project or the purchase. And so if the conditions are not satisfied, money is not released. So if a finance minister signs off on a letter of credit, he's actually applying due diligence and applying prudence. To then prosecute him when the subject matter experts in the ministry and the rest of who are directly responsible for making sure that those purchases were sound have been left off the hook makes no sense whatsoever.
Okay.
On the second matter,
that may not be the same as all the other cases because that one, you can say Ato Forcing and his colleagues, they won the case.
Yes, they won on appeal.
Yeah, they won.
Yes, on the submission of no
appeal.
case.
So the Attorney General is now in the Supreme Court, right? True. And that's where they have gone to withdraw.
They've withdrawn the case because I think it was an abuse
the appeal.
Public
the former Attorney General says he believes that case, they would have won it. They would have won the appeal.
That is, everybody has their opinion, right?
Okay.
Those of us as bystanders who had no stake in the game, I would have told you that forcing case should not have been brought at all. It was one of the worst I have seen. Anyway, on Saglemi, I have cause to agree in parts with the arguments he made. Some of the arguments that the current Attorney General presented just didn't hold water. I mean, if you said $200 million had been part of it had been spent building houses, and so to my mind, the $200 million charge was defective. The argument that the former Attorney General makes is very solid, which is that they should have just amended it and said this is the amount of money that I felt was still in play. I was also not happy that he only addressed, and this was actually the challenge, because on the one hand, everybody's praising the former Attorney General for being transparent and seeking to justify his decision making. But on the other hand, he was not very comprehensive. So in the Saglemi matter, for instance, there are 70 charges that were preferred against the former minister. He addressed one of them, which was basically the cause financial loss to the tune of $200 million based on wrongful application. What about the 6 other accused persons, including one former minister of Works and Housing, who is also, most people don't know this, implicated the Pualugu Dam matter, and we don't fully know the details of his involvement. So I think that in that matter, the Attorney General could have been way more comprehensive. The current Attorney General could have been way more comprehensive because it is actually difficult to understand how everybody in that case did not do anything wrong, including the contractor and these variations that were approved and the rest of it. Then on the issue of Johnson Sema, which is why I have the greatest disagreement with the former Attorney General. No, the former Attorney General.
Rather?
Yes, because these are matters that are not only legal matters. In fact, everything here is generally public policy as well. Because even the decision to prosecute or not to prosecute is not entirely legal. There are a lot of public policy considerations that go into it. But I think this matter was extremely interesting because in the banking and finance sector, it's not only the legal issues that are important. There are other issues around macro-fiscal stability, etc., that are important. The current Bank of Governor was executing policy that his colleagues in the Bank of Ghana agreed with. He was executing policy that they agreed with, which was that we should use the emergency liquidity program, the fund that we have to support banks that are in distress, not in distress, but are having liquidity challenges. We should use it to prevent banks from failing. There are two types of liquidity provisions in this respect. There is the emergency type that you use, which can extend to as much as 3 months. That is, we can give you the money as a bank as much as 3 months. Then you have the intraday, which is extremely critical because the intraday means that if a bank is failing settlement, the central bank can step in to enable the overall processes in the financial system, the banking system, to continue flowing. Essentially, what happens is when you pay someone money, let's say you have a bank with, you have an account with one of the banks, let's say Bank A, and you are paying somebody in Bank C, there has to be a settlement process because the bank, it's not the same, the accounts are not held in the same bank. So it's not just a matter of moving ledgers. You need to typically have a central bank situation where they debit the accounts of the different banks. If at that moment, the bank that it's being debited doesn't have money in their settlement account, it can lead to payments being failed. And this can have serious distress elements across the entire financial system. So if because of all of these factors, a decision is made that we cannot allow contagion in the banking industry, so we will give money to Unibank through UMB, because at that time, Unibank, I think, did not qualify to receive it directly. And this was a matter approved as a matter of policy. How do you pick up one of them, the deputy governor, and then sue and then prosecute him? I think that was very difficult. On the UT matter, where the former Attorney General suggested that because of single obligor, 460 million should not have been paid, I could not make head or tail of it. I could not make head or tail of it.
Explain.
Because single obligor is in respect of the bank. You are prevented from giving too much of your money out to a single person because you are concentrating risk. But the central bank is not obliged to observe single obligor if you are giving liquidity assistance. You understand what I mean? If the central bank is giving liquidity assistance to a bank, what is the single obligor issue in there? So I struggle to understand what he meant that, it was in violation of single obligor limits when the central bank was giving money to UT Bank to the tune of 460 million cedis. If UT Bank was underhand was giving all that money out, and you suggest that they were breaching single obligor limits, I will understand, but that will have nothing to do with the central bank. The argument that we've had so far is that the previous administration was lax when the asset quality review was done in 2015 and 2016 in not pursuing it further to hold some of the banks to account. And then all of us have had policy issues today. But remember that the law that is being used, which gave the Bank of Ghana all these powers that they exercised so liberally during the resolution, that law was passed in September 2016.
Correct.
Long after these matters had occurred. So the instruments were not available to the central bank to tackle the situation in the manner in which this new administration or the one that followed them, their predecessors, were able to do. So to turn all these policy matters into a criminal indictment, I think was just bizarre, completely bizarre.
Okay.
And, on the issue of the memo, now I'm pretty sure Bank of Ghana, your station is going to publish it, so I need not comment on it because now we know that that was not correct. Where I think that the previous Attorney General or ex-Attorney General was correct is in the $5 million, the claim that Honorable Atacha approved the $5 million. Because we do know on record that it was approved by the Chief Director. And we also know that at some point, there was even a consideration of charging the Chief Director for doing it without authorization of the Minister. So I'm not sure how they could make those kinds of mistakes. So that is the case by case. And what do I mean by all of this? All I'm trying to say is that we have to examine these matters on their merit, whether or not they were valid or not. And independent bystanders who are in the public policy space can make that comment. Right. On the last point, on the big issue of principle, my biggest challenge is on principle. Because on what basis have they selected 7 or 20 cases? We have hundreds of people on remand. Some of whom have been on remand for more than 5 years. I'll give you a very quick statistic. Around 2017, 2018, about 25% of all the prisoners we had in this country were remand prisoners. About 3,000. Do you know why we have only now about 995 today in remand? Justice for All program. There was a consistent policy that enabled amnesty to be applied. How do you determine upon coming to office within a week that so and so case is so urgent, is so egregious that I'm able as Attorney General to determine that as a matter of public policy we need to discontinue those cases? How did it come by the selection? And I think it would be very good if the Honorable Deputy Minister designate walk us through how did they what was the filtering mechanism? Is it all defense attorney petitions? If so, was that an open call so that other defense attorneys in this country can approach them? Because I think that baffled me. Secondly, even if there was a mechanism to enable fairness to be applied in this respect, On what basis then do we have a situation where, for the same particular situation, an individual gets off and others who similar facts have been applied to their conduct don't get off? It gets very, very confusing.
Right.
So those are my concerns.
Thank you very much. And so you should be answering questions. And Dami had very, very critical questions for you to respond to, some of which, Bright Simmons agree with. Some of the issues that were raised by Dominic Ayine, there are many who agree that it makes sense. For example, the query that was made, and this is what Dami said: I must indicate that I find the line of thinking of Dr. Ayine that simply because an alleged loss to the state is recoverable after the offense has been committed or the charge filed, the offense of willfully causing financial loss is rendered invalid. Very strange and unsupportable. Also, an amount paid in violation of a law, when subsequently recovered, does not clear the person who gave the approval to be made of criminal wrongdoing in the first place.
Samson, first of all, let's agree that there is a vast difference between Godfrey Dami and Dr. Ayine. In terms of, I'm not talking of the fact that one has a PhD and one doesn't. That is not what I'm talking of. I'm talking of the very appreciation of personal liberty.
PhD is important. Some of us have run away from it. It's not an easy job.
Well, but that's not my point here.
Okay.
I mean, the very appreciation of personal liberty is important here. You and I have been on this criminal defense for some time. What goes into a person waking up every morning and coming to court, being called, cases being adjourned, the cost, you can't do anything because you have to be in court. I mean, we just talked about someone who has been declared as a fugitive, right? If you have respect for personal liberty, you will not sit and argue that, well, if you think that the person is innocent, why won't you allow him to go through the entire trial for him to be declared innocent? When you know, as a prosecutor, exercising your professional judgment, that this cannot lead to conviction. We're talking of a particular...
In that case, what happens to Judge Kwesi? Because Chachuchi Kata says, this is my case, I want my client to prove his innocence, the Attorney General says, well, I left that one, but I wanted to file another prosecution.
Let me just continue from where I left off, and I'll answer that question. For example, you have a memo which has been given to you. I know the former Attorney General said that he never had any memo. That cannot be true because the records, and I will encourage you to apply under the right to information laws to the Attorney General's department. And you will see copiously that there is clear record of the Attorney General the former Attorney General, having been, served with a memo which clearly says that this case conviction cannot be possible. And yet, he gave comment on it. He was saying that he never gave comment.
He didn't say cannot, he said may.
Well, at the end of the day, he may. The context, if you put it in the context, he means that he cannot. Eventually, there's evidence that he had a memo, he minuted on it, and took decisions contrary to what the memo said. And what Dr. Ayine was saying was that, look, there's no problem if you feel that you can override the DPP, but to deny that indication came to you in the first place, when it did come to you, is to be dishonest. And secondly, look, we are talking of one of the issues that the former Attorney General said was that the AG did not consult the president in taking the decision to what?
Before you get there, you say there was a memo, you minuted on it. Dami wants to know, what did he say when he minuted on it?
He denied that there was a memo. I think that is sufficient.
That's right.
As to what he said, that's why I said that you apply to the ministry.
There's something I have become familiar with,
okay,
and I've already shared with the members of the public. Mm-hmm. What I've become familiar with and information is that there was the shredding of a lot of documentation.
Indeed.
And that in the course of the shredding of the lot of documentation, it does appear that this particular memo either was shredded or was taken away. But there was a certain tray that has been traced to this memo.
Precisely.
And that's how come there is the one that I have seen and I have shared with the public.
Perhaps the denial...
The one that I have seen and shared with the public does not have minutes. It's not minuted.
The point I'm making is that there is evidence that such a memo exists. There's evidence that the memo was given to the Attorney General. There is evidence that he has responded he has minuted and he has responded to the memo.
The evidence that it exists, I have confirmed that.
So
my
now,
viewers.
as to that point, let's establish that
Right.
he lied to the public when he said he was not aware of any such memo. That's what he said.
First, he said it does not exist. Then later, I think he was cautious and said if there was, nothing of the sort came to his attention.
And now all of them are false because it existed, it came to his attention, and he minuted on them and directed the DPP on what to do. And I'm saying that if you doubt what I'm saying, you can apply, and I'm encouraging you to apply to the Ministry of Justice, Attorney General's Department. You may be given a copy.
I've had the opportunity to see. I've not been offered a copy, so I'll try it.
So at least there's a common ground. Now, the point I'm trying to make is that if one of his concerns about the Attorney General was that he took decisions without consulting the president, and that he used his personal authority to enter this nolle prosequi. But that also shows a certain level of misunderstanding of the Attorney General's powers. And I'm surprised that for a former Attorney General, who also served as a Deputy Attorney General, to diminish the extent of the power of the Attorney General, to suggest that every decision that the Attorney General is supposed to take, he has to go and take direction from the President. Because the Constitution itself is clear that the Attorney General has two sources of. One is those that the Constitution imposes on him, and those that the President may assign him. These are the two, if you read Article 88.
But these are very important cases, significant on our national economy.
You see,
the banking collapse crisis.
You see, the Attorney
How does the Attorney General take a decision without recourse to cabinet?
The Attorney General's office power is sui generis, okay? When it comes to prosecution, because that is what the Constitution says, that it is he decides who to be prosecuted and who not to be prosecuted, whether to continue the prosecution, whether to end it. That is for him. The President may indicate to him that based on this and this, I am assigning this to you, which is also lawfully under the law. That is why we always say that we need to decouple the Minister of Justice from the Attorney General's authority, because the Attorney General, as Attorney General, is a completely different thing. And as in his capacity as a minister, the President may use that power to assign him some work. But to suggest that if an Attorney General wants to enter nolle prosequi or wants to take every decision, he has to go and take direction from the President.
Before we move away,
yeah.
The Johnson Esiama matter, there were two different cases, not one. Yeah. Attorney General Dame says that you also sought to confuse both, as if that even if there was a memo, it's in respect of both. But it does appear it will be in respect of one. Is that not it?
The memo was in respect of one. But that is not the only reason why the memo is not the only reason why the nolle prosequi was entered. So if his concern is that the memo is for one, there are other considerations which the Attorney General outlined, that he has assessed the docket, and in his knowledge and his experience and his professional capacity, he realizes that these cases were not going to land in any successful prosecution and shouldn't have been started in the first place, and some of which Bright has explained. And those cases must be taken off. Now, this brings me to the next issue of calling the whole thing OCAL. There were 7 cases. About 5 of them had nothing to do with looting. So if you say it is operation...
Still, the memo is referable to the...
One of the cases.
The Unibank case.
Yeah.
Then there is the other case where Johnson Esiama is involved, which is about the UT Bank case.
Yeah.
So how come he gets,
and I am saying
a clean bill for both?
So what I'm saying is that from the Attorney General's explanation given, he did not just base his decision on one document. He said he has assessed the docket, he has consulted with the prosecutors, and he has also spoken with the defense attorneys. And from where he sits in his judgment, he believes that none of the 2 cases were going to lead to any conviction anyways. And he sees no reason for persecuting or subjecting someone to a criminal trial when he knows in his heart of hearts that this is not going to lead to anywhere. So
Bright has just explained here the question of the violation of the single obligor limits, which is the UT matter, which the memo did not cover.
Yeah, the memo is on there.
That doesn't make sense to him. But Domkain didn't say this to us, like Bright has put it, that the single obligor matter, it doesn't make sense.
So we need to take the press conference in 8 terms. For example, if you take the Ofusampofu situation, there was no comment on there was no attempt to explain.
Ofusampofu and Kweku Boahen, right?
Yeah, there was no. So we should not take the press conference as the totality of the things that, because the press conference had to, when you are doing a press conference, you need to consider the time limit and all that. So we shouldn't just take the press conference as the only decision. But I think we should take the Attorney General's word when he said that from his professional position, he has examined all the dockets, he has consulted widely, not just with the department, the prosecutors in his department, but also with defense counsel and even people beyond that. And he had come to the firm conviction that these cases, and there are many more to come, these cases were not going to lead to any conviction.
There are many more to come.
There'll be more cases.
It's unprecedented in our history.
Because, you see, we should be...
That you are entering discontinuing cases.
It is equally unprecedented that it is...
Imagine that another government comes in the next 4 years and its members are being prosecuted and they decide to enter nolli prosequi. What are we making of the judicial system?
What is unprecedented is an Attorney General who has been partisan for all the years that he's in office and has decided, even without evidence, to persecute people. That is what we should be concerned about, not the person who has come to save the situation. I mean, if you put someone in the criminal justice system and you go to sleep for all these years, and someone comes to say that I have examined what you have done, you have no real basis for continuing this, for starting some of this trial.
If the evidence exists that will not lead to their conviction, and some of the cases are just about to finish, why don't you finish it and allow the court to acquit and discharge them?
Why I'm saying
and
it depends on how
in the Unibank case, the prosecution had closed its case. So the withdrawal means that Johnson Esiama is acquitted and discharged. But in the other one, I'm not sure they closed their case. So it means there's room that in future he may suffer, right?
No one deserves to be put through the ordeal of criminal trial, even for 1 day, if there's no basis for it. So the fact that they have suffered this period does not justify any attempt to say that
there's no basis where the courts, in almost all these cases, the courts have come to the conclusion that they have a case to answer. And they are in the processes of answering their case. So how do you come to that conclusion?
If the court was the most appropriate place to determine this, I don't think the lawmakers would give the Attorney General the power of nolli prosequi. They would have just said that once you start trial, allow the court to go. But in the wisdom of those who design our criminal justice system, they have a reason to give the power of nolli prosequi, which could be exercised at any point in time. That shows that they understood that the yardstick that the courts work with may not necessarily be the one that the prosecutorial discretion will be applying. So we cannot say that asking for nolli prosequi means that the courts are not effective or anything like that. We are just saying that to subject a human being, a citizen, to criminal process. I mean, I'm surprised that we are making this comment. We were here.
I'm sorry, but I have to cut you here, and because we are just running.
Let me make this last point.
Let me go to Frank Davis.
No, let me make this last point
quickly in a minute.
Let me make this
in a minute.
Yeah, in a minute. I mean, so I was saying that to tag this whole exercise as OCAL, Operation Clear All Looters. It's actually very unfortunate because the person who made this is my very good friend. And I'm just imagining a day where he would be in this system, this unfair criminal trial, and will now be ordered, when he's given relief, he will consider himself a looter. I mean, what has Ofusampofu got to do with any looting? What has Atoforsin got to do with any looting? What has Saglemi got to do? Saglemi was misapplication of the funds. It has nothing to do with looting. Esiama, the evidence shows that the money has been recovered.
But the cases that are being called looting are similar.
No.
Okay. No, Mr. Frank Davis, Frank Davis, let's hear you on these things and what it portends for the future of our criminal, jurisprudence.
Something, you have shortchanged me. All of them have spoken at length. If the program is going to end at 12, I have only 8 minutes, but let me try. I'm very disappointed, and I must confess with some of the things I've heard. My very good friend, the Deputy Attorney General, say, hey, I'm really disappointed. Because I always say we are all trained lawyers. Yes, we have political coloring, but when we are discussing certain matters, our sanctimonious fidelity to the law should be paramount. It should be paramount. You know, justice. You see, we can sit on TV, radio, and say the kinds of things we say.
Because this is personal. So
yeah, but okay, you have the right to reply. Don't worry. You said so many things. You see, when you make judgmental calls on people, you should also hold yourself in readiness for the responses which will come. When you say the former Attorney General, look at the language you use. I don't want to repeat it. I mean, you go to the point of saying he's persecuting people, but that is not fair. You don't have the right to judge him that he's involved in persecution instead of prosecution. You don't have the right. Justice, please, with all due respect, you don't have that right. So let's be cautious about the language we use. Look, I'm minded to borrow Bright Simmons' language, that on this matter is principle. Let's stick to principles. Justice Semsai, maybe you've been out of this country for so long, but the Attorney General, Dominic, is my very, very good friend. When you go ask him, he knows. I think this is the first in the political dispensation of the Fourth Republic that an Attorney General has involved in this wholesale instance of nolli prosequas and withdrawal of charges against politically exposed persons in this jurisdiction. And it is worrying. And that is what something was minded for you to respond. You didn't respond to that. It is worrying, you see, because at the end of the day, any other Attorney General can come and then decide that take it or leave it. When there are cases against politically exposed persons, all those persons will be wiped. Give me one instance of the people who have been wiped who are not politically exposed persons. Justice. You see, when we are talking principles, we should be bold and firm and not stand on quicksand. Because when we stand on quicksand, we will sink. You are talking about the fact that people should be subjected to their personal liberties. Excuse me, criminal prosecution has nothing to do with personal liberties. Nothing at all. Maybe we should all go back to first steps of criminal jurisprudence. Criminal prosecution has nothing. It does not run in tandem with personal liberties. The prosecution has to prove your guilt. That is the burden. You are not at liberty to be suffered at large. No. But when you say the office of the Attorney General is sui generis, what do you mean by that? How can the office of the Attorney General be sui generis? It is not. Yes, it is only the Attorney General whose qualification is called into sharp recourse when that is no other person than a lawyer can be an Attorney General. Indeed, for all the ministries, anybody else can be a minister. I'll stretch it by saying that maybe the Ministry of Finance you need, but there have been occasions that the Ministry of Finance has been run by chartered accountants who are not economists, and they have performed very well. But Justice, the office of the Attorney General is not sui generis, if we all understand what is sui generis. And with great respect to the Attorney General is the chief or principal legal advisor to government. These are cases which involved financial losses to the state, whether wrongly or rightly. How can the Attorney General say, Dr. Ayeni, how can you say to Ghanaians that this is your personal responsibility? It cannot be your personal responsibility. You cannot take this decision to enter nolli prosequas and withdraw those charges without consultation to the presidency. If you did that, don't do it again. You can't tell anybody.
Is the argument that...
Excuse me. When you were talking, I was quiet, please.
Writing the president approved it. Is that the argument?
When you
all
take
of a sudden
such
right.
decisions, you are a senior cabinet minister. You advise the government on all legal matters. Now, if there is this thing, Ghanaians are applauding this government for an operation recover or loot. And then there are persons standing prosecutions in court, and it involves money. Then you go to clear them. Like something said, if the Attorney General was definite that the charges that have been preferred will not stand the test of time. Why doesn't the prosecution run its full course? The reasons he gave, some of the, excuse me,
maybe we'll have a lawyer's file. My time is up. Unfortunately.
Excuse me, some of the charges were defective. He says others amounted to political witch hunt. Thirdly, the conduct. That is where the conduct of some of the judges left much to be desired.
Yeah, and some of them he was involved and he had taken a decision and he could not, for ethical reasons, continue.
The conduct of the judges left much to be desired, and some of them were promoted. Come on.
He said he didn't mean to impugn them, but he said so. I'm sorry.
This leaving of prosecution to politicians is not going to help us.
Right. And Kofi Bentil says that in fairness to the public, let's say the AGs were doing politics, not law. The law has been used as an excuse for political decisions. My outfit is by Konati Clothing.
Samson,
I think you can call them on 0244 676732. I'm sorry, Justice. People pay for this show. This show is brought to you by Bank of Africa, as strong as a group and close as a partner. MTN everywhere you go. HSC University, educating ethical and entrepreneurial leaders for Africa. Robert and Sons Optical Services, your comprehensive eye care service provider for 33 plus years. My Way Insurance, dial *165#. On MTN to join My Way today. DBS Industries, Roofing, Papa Fie, Flamingo Paints, Simply Superior, Syntex Tanks. It's strong, it's tough. Activa International Insurance. Our clients are passion. And the mass sacking matter, we should deal with it at another date, but we see that there is some indiscriminate process that clearly may have to be questioned, because some of the employment or recruitment were done long before December 7, and yet they have also suffered. We have evidence of that. Next week, God willing. Have a good afternoon.